Good evening, friends. Today we are here to discuss about Section 8. Section 8 of the Act. So I'll first of all just go through the bare wording of Section 8, which is dispute resolution. In fact, friends, dispute resolution clause is a clause which is the root cause of disputes between the farmers and the introducers of this legislation. Why is it so? Because the farmers have been stripped of their fundamental rights to approach the law courts. In fact, by the operation of this act, the farmers will have to refer their dispute to a subdivisional magistrate or an SDM. And at the first instance, the SDM shall refer a dispute to a conciliation board. And in this conciliation board, which will consist of a chairperson who will be appointed by the subdivisional magistrate himself, and the number of members would be between 2 to 4, meaning thereby that there could be 2 members or 3 members or 4 members under the chairmanship of a person who would be appointed by the subdivisional magistrate, and such chairperson would be reporting to the subdivisional magistrate and would be working and acting under the thumb of the subdivisional magistrate. Another interesting provision in Section 8 is that both the parties get an opportunity to give the names of 2 representatives or representatives who shall represent them, who shall form part of this conciliation board. So say for instance there are 4 members, out of which 2 members are to be appointed by the farmer and other 2 are to be appointed by the trader. But the proviso says that in case the farmer fails to make an appointment or to give a name of such 2 persons, then after the expiry of a very short period of 7 days, the subdivisional magistrate will have a say to appoint these 2 persons out of the names that he likes, to whomsoever he may hand over the job. So let us just summarize this. So the moment the dispute arises, the farmer will make an application, or one of the parties will make an application to the subdivisional magistrate for conciliation proceedings. Subdivisional magistrate will have an opportunity to appoint a conciliation board which could consist of 1 chairperson and a number of members between 2 to 4 to undertake conciliation proceedings between the farmers and the trader. But there is a lacuna here. There is a caveat here. In case of any dispute arising out of a transaction between the farmer and a trader under Section 4, the parties may seek a mutually acceptable solution through conciliation. So the parties, when they approach the law courts, they do not approach the law courts for seeking a mutually acceptable solution. They approach the law courts for seeking justice, seeking equity, seeking operation of principles of natural justice. But in a very hasty manner, in a very twisted manner, a provision has been made here that once the farmers approach the conciliation board, then efforts shall be made to resolve the dispute, not decide the dispute, but resolution of the dispute through a mutually acceptable solution. So firstly, you are stripping the farmers of their fundamental right of approaching the law courts. Otherwise, if this clause was not a part of the act, the disputes could have been sorted out by the farmers or by the other person, by the trader, by approaching the civil court concerned, which would be civil judge junior division or civil judge senior division in the hierarchy of courts, as the case may be. Upon decision being taken by this court, a party to the dispute would have had an opportunity to go before the next court, that is the first appellate court or the court of district judge or the additional district judge, as the case may be. Then still Further, the parties would have got an opportunity to vindicate their stand before the second appellate court, which would be the Honorable High Court. And if the parties were not satisfied even by the verdict given by the High Court, they would have had an opportunity to go before the Honorable Supreme Court. Over here, by narrowing down the compass, we are only giving an opportunity to the parties to approach a subdivisional magistrate, which is at the most be called as a quasi-judicial authority, a half-judge. Another factor which is worthwhile to mention over here is that we are thinking in too optimistic terms if we were to say that farmers in India are so aware that whenever a dispute arises, then within a snap period, within a very short period of 7 days, they would be able to point out as to which members should be appointed on their behalf. And so therefore, within 7 days, if the farmers fail to do so, the SDM gets an opportunity to ask two members or two or more members to make a backdoor entry on behalf of the farmer, and such members are to form part of the conciliation board, whom the farmer doesn't even know who he is, and the farmers don't know whether they are going to actually represent the farmers or not. And at the most, what is to be done is that a mutually acceptable solution is to be found out. So in India, where the farmers generally sometimes do not even know how to put a thumb impression and where to put it, and the farmers do not know how to write a check, how to sign a check, how to encash a check, such fundamental rudimentary things, the farmers are aloof of such factors. It is too optimistic for us to think that the farmers would be so proactive in initiating litigation and going by the procedure that has been set under the provisions. Every board of conciliation appointed by the subdivisional magistrate under subsection 1 shall consist of a chairperson and such members not less than 2 and not more than 4, as the subdivisional magistrate may think fit. So a lot of discretion has been granted to the subdivisional magistrate. It seems that subdivisional magistrate is ruling the roost. The chairperson shall be an officer serving under the supervision of and control of the subdivisional magistrate. So it is absolutely open for the subdivisional magistrate to appoint, I should not use this word, but to appoint a stooge or a person who is working under his thumb as a chairperson of the conciliation board. Now, another thing that is worthwhile to mention in section 8 is that the subdivisional authority shall decide the dispute or contravention under this section in a summary manner within 30 days. So what do you mean by a summary manner? Summary manner would mean that it would be too optimistic for us to be thinking that the farmers or the parties before a conciliation board or before the subdivisional magistrate would get an opportunity to effectively pursue their case, because they will not be granted an opportunity to lead evidence. Either they are going to lead evidence on oath, on affidavits, and then in that case also there may or may not be a cross-examination. So therefore the case may remain half-baked. So basically the matters that matter to the farmers so much will be decided in a summary manner, a manner in which the consumer complaints are decided, a manner in which the SARFAESI proceedings undertaken by the bank are decided. So basically, we all know that even under SARFAESI proceedings, how many times a district magistrate decides against the bank in favor of the borrower. We all know about the ratio of the cases that are decided in favor of the borrowers and against the banks by district magistrate. Of course, he has got a very tight rope to walk on, and even if he wants to use his discretion for the reasons best known to such quasi-judicial officers, they do not use the discretion in favor of the victim, the party which is agonized by the action, whether it is the borrower or whether it is the farmer. It is too optimistic for us to think that a subdivisional magistrate would undertake these proceedings in a fair manner. One more thing, this conciliation board, which will be appointed by the subdivisional magistrate, gets only 30 days time to conciliate and to settle things between the parties deciding. So therefore, by making a provision of deciding the case by resorting to summary procedure, the legislation has certainly let down the farmers because they will not have any effective opportunity to pursue their case by way of leading evidence, etc. At the most, I believe, and that too if the procedure would permit it, I believe, as I see things, once the SDM decides the dispute, it may be amenable to writ jurisdiction of the Honorable High Court. And even when you go before the High Court in a writ petition, the farmers would have a very tight rope to walk on, because you invoke a writ petition only when there is a strict violation of fundamental rights. So therefore, otherwise, even if there are certain issues that require detailed evidence, and such evidence, of course, we know is not permitted in a summary procedure. Normally the courts don't permit such evidence to be led in a summary procedure. So it will be very difficult for the farmers or the parties to sort of vindicate their stand before the High Court, even if a civil writ petition is filed tomorrow. Once again, the decision given by the SDM would be, we were just speaking about where would this be challenged. This would not be challenged directly in the High Court, as I just said. I'm sorry. It would be amenable to the jurisdiction of the collector, that is the DC or the DM, who would sit over as an appellate authority over an order which is passed by the SDM. So basically, one quasi-judicial authority will sit over the decision given by another quasi-judicial authority. So basically, this we do not expect the DC to apply any mind beyond what has been applied by the SDM as well. One little segment before we wrap up this video. What is so unfair or ghastly or bad about an SDM that the farmers do not trust him or believe in an SDM? I mean, why is it so that the farmers do not want to put themselves before an SDM and to refer the disputes to his jurisdiction, SDM or a DC? Recently, we saw that while certain farmers were protesting against some political activity in Karnal, a celebrated subdivisional magistrate by the name of Ayush Sinha was seen and heard in a verified video in which he was seen directing the police personnel to break open the heads of the farmers if anybody wanted to protest against the political activity in the area. So these kind of activities, they have let the farmers down a big way. Today, when the farmers protest against laws, when you can give orders of brutal lathi charge, the farmers would be looking at it as a pre-cap, as a preview to what is going to happen tomorrow. Tomorrow, when they come to you to seek justice, is this how you're going to deliver justice? Is this how you're going to welcome them? The farmers enjoy an equality of law in front of massive, mighty powerhouses, the traders who are going to, bulldoze themselves upon the farmers. These are the questions which are worthwhile to apply mind to. Thank you very much for watching my video.